Hello, I'm Adam Kielich, the principal attorney at the Kielich Law Firm in Bedford, Texas, and today's quick video is about cat's paw liability. Cat's paw liability is a theory of liability in employment litigation in which an employee alleges that something unlawful occurred because the employer took advantage of the different levels of management to make an unlawful act appear as though it was an honest act, even if somewhere along the way somebody had done some bad things. So we'll talk a little bit about how it came to be that this theory was accepted by the court. Certainly, we're going to talk in more depth about what cat's paw liability means, and we'll talk about a few examples of how it works and why it's important. Let's actually start off with an example because it's easier to understand cat's paw liability this way. Say you have a company where the employees report to a manager and the managers in turn report to a director. And before a manager can fire an employee or take some other serious kind of adverse employment decision or action against the employee, the director has to weigh in and make the final decision. This is a fairly common setup. Sometimes in other employment settings, you'll have the employees report to a supervisor, some other sort of intermediate manager, and then the final decisions about hiring or firing might be made by an assistant store manager or the store manager or a warehouse manager or whatever it might be. So we'll take this fairly common employment situation and apply our cat's paw liability to it. Let's say in this situation that we have an employee who disabled and of course works for managers and directors who are not. The manager decides he doesn't really like having this disabled employee. There's a reasonable accommodation for the work. The manager hates it. He just wants the employees to be able to come in and do their job without an accommodation. Now, he can't go to the director and tell her, I want this guy fired because he has a disability. It's a pain. I don't want to deal with it anymore. So instead, what he does is he goes around and maybe he observes the employee more than his other direct reports and tries to nitpick and find reasons to write up this employee. So he writes up the employee 3 times. He satisfies the company's progressive disciplinary policy. He takes it to his director and says, look, this guy's a problem. We got to let him go. Director looks at the reports and says, well, he's been written up 3 times. Yeah, we should go ahead and fire him. So she calls in the disabled employee and says, look, you've got some performance problems, you're out. Now, in this situation, the director had an honest belief that she was making an employment decision based upon this employee's real performance problems. However, the director does not know that the reason the employee was written up is because the manager was motivated by this discrimination to write up the employee. Really, whether the reasons for the write-up are legitimate or not, if the employee was over-analyzed or was nitpicked more than any other employee, then there may be some actual problems with the way that the write-ups were done. But let's not get too much into the weeds about that. Let's just make it clear that the employee was not acting unreasonably or had any serious performance problems. The manager wrote up the employee because he wanted him out based upon that disability discrimination, and our director made the decision based exclusively upon those write-ups and has no idea about this discrimination issue. In this example, the manager is using his director as the cat's paw to do his dirty work. So by doing it this way, the manager is able to make the termination appear legitimate, even though the manager is getting away with discriminating against the employee on the basis of his disability, which would, of course, be uh, disability discrimination under the Americans with Disabilities Act as well as the Texas Labor Code. For a long time, the problem in these situations is that the employers would go into court and allege exactly what I said, that there was an honest belief that the director really believed that a neutral employment decision was being made based upon this employee's performance. And this defense actually was fairly successful for a long time because you had somebody who, had they known that discrimination was an issue, certainly would not have made the decision on that basis and probably would have actually taken action against the manager. But you've still got a situation where an employee has been terminated, where a motivating factor in that whole chain of events that led to the termination was an unlawful form of discrimination. However, plaintiffs kept advancing these claims and were losing at court to this honest belief defense that employers were putting up. Eventually, the United States Supreme Court weighs in and says, wait a minute, look, employers cannot unlawfully discriminate against employees and get away with it purely by playing one level of management against another. Each level of management is part of the employer, and the employer has a duty to make sure that the decisions are being made are not motivated by some unlawful factor. So the Supreme Court fashioned what's come to be known as cat's paw liability, in which an employer can be held liable when one level of management concocts what appears to be legitimate reasons for an adverse employment action, and then another level of management executes the adverse employment action based upon that concocted, legitimate appearing basis. The supervisor or manager or director or whatever their title is, whoever that member of management who makes the employment decision, either must make their own independent inquiry to figure out whether this employee should suffer the adverse action, or be willing to accept the liability that whatever basis they're relying upon is legitimate. If the underlying basis for the adverse action turns out to be motivated by an unlawful form of discrimination, the employer is held liable under this cat's paw liability theory. And the reason why this makes sense is because every level of management and every person within management for the employer is the employer's agent. It shouldn't be acceptable for the employer to let one level of management have the motivating factor for of unlawful discrimination or some other unlawful motivation, and then let another level of management just assume that it's all okay and do whatever the other level of management wants, because that really allows the employer to take a blind approach to the discrimination and not really investigate and make sure that the employment decisions that it makes are neutral and not based upon some sort of unlawful factor. That is a very basic understanding of cat's paw liability. Like everything else in employment law, it's full of exceptions and nitpick rules that have to be understood. But for the purpose of a short video, let's just sort of keep it at the surface level. If you're wondering what the term cat's paw liability is and what the cat's paw is, it relates to a fable called The Monkey and the Cat. And in The Monkey and the Cat, the two animals are pets within this house, and there's a fire where chestnuts are being roasted. And if you've ever seen chestnuts being roasted, or really any kind of nuts, you'll know that as they get hot, sometimes they pop and they'll pop out of the pan. Well, here these chestnuts are popping out of the pan, and the monkey looks over and decides that it wants to grab these loose chestnuts. But the monkey is smart and doesn't want to burn its paws, so it convinces the cat to go slip in and dig out these chestnuts from the burning embers of the fire and tells the cat, if you'll dig these out, we'll share them. Cat says okay, cat goes to work. As the cat is pulling them out, the monkey is eating them all, and eventually a maid comes in and scares them both away before they finish their work. The cat ends up getting no chestnuts, and the monkey has eaten all of the chestnuts that were pulled out. So the term cat's paw means to have somebody else do the dirty work, and whoever it is that is doing the dirty work is the cat's paw. So this is what the Supreme Court has said is cat's paw liability. It's a valid theory. And let's talk just a little bit about, or let's work through some examples. We've already talked about the basic level of how this works through an example. Sort of an example of where cat's paw liability does not work would be a situation. Let's take our same employee, manager, director chain. Here, maybe the manager wants to discriminate against our disabled employee, and so he's concocting these write-ups, but the director independently maybe sees the disabled employee drinking at work on the clock in a back corner and then going and operating equipment. And obviously that's going to be a problem in the workplace. So the director walks up and says, hey, saw you drinking, you're fired, get out of here. In this case, yes, the manager was concocting these fake reasons to terminate the employee, and they were motivated by that unlawful factor, the disability discrimination. But the director's choice to fire the employee, to take that adverse action, had nothing to do with what the manager was doing. In that case, cat's paw liability would not apply because the director's decision was independent and unrelated from the discriminatory acts by the lower level manager. And that's one of the important rules with cat's paw liability. There has to be a direct connection between the motivated conduct of the one level of management that is motivated based upon this unlawful reason or factor, and the adverse action that's taken by the neutral level of management. Otherwise, you don't have a discriminatory act where the adverse employment action is being caused by a desire to discriminate against an employee on some unlawful basis. In both of the examples we've talked about so far, you have the manager instituting some sort of formal disciplinary act motivated on that discrimination. But that's not the only way that cat's paw liability can arise. You can also find cat's paw liability where the manager, using our same employment chain, where the manager is taking informal actions to poison the mind of the director against the employee, maybe in their meetings or one-on-ones. The manager is telling the director how this person is a problem, they don't work well with others. The manager may try to sell that they're trying to help this employee, but the employee is just difficult to work with and difficult to manage. That would be good enough as well if those comments as a whole in turn motivated the director to take some adverse employment action against the employee. Cat's paw liability can also arise where coworkers are maybe telling the manager that this disabled employee is a jerk, that he doesn't work well, he's not doing his job, he shows up late, he leaves early, He's having other people clocking in for him, all kinds of things that would make the manager have a legitimate reason to take some sort of adverse employment action against the employee. In that case, the manager then still has that same duty to make an independent investigation and determine whether what the coworkers are saying is true or if something else is going on between all the employees. In this case, if the manager makes an employment decision based upon what the coworkers say, and it can be proven that the coworkers are discriminating by creating a hostile work environment or whatever against the employee to try to get rid of them but make it appear legitimate, that could also give rise to cat's paw liability. So it's not necessarily always one level of manager promoting or motivating another one. Sometimes it can be coworkers motivating a manager to do something. So far, it appears that this cat's paw liability theory is going to hold on. Certainly, with the Supreme Court weighing in, it's going to be difficult for courts to erode or disagree with the theory itself. But for now, we've had just a handful of cases come up in the appellate level courts, and it appears that they're following pretty similar paths to what the Supreme Court has said. So if you find yourself in a situation where you feel like maybe your manager or your coworkers are trying to discriminate against you on some unlawful basis, and they're trying to manufacture what appears to be legitimate reasons for your manager to get rid of you or transfer you or demote you or whatever, this may be a cat's paw situation, and you should talk to an employment lawyer in your area as soon as possible.